Hi, good evening everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here with the attorney Prashanthi Reddy garu today to discuss the latest updates on immigration matters and the frequently asked questions and any latest immigration updates that we have. You can call the numbers displayed on the screen. I would like to repeat the disclaimer. Please note that this show is not intended to provide any legal advice and it's very general in nature and is only for informational purposes. Sakshi TV news or agents are not responsible in any way for your actions. Use of information is at own risk. So, hi Prashanthi garu, welcome to the show.
Hello, Andy.
Yeah, we have few updates that we would like to discuss and then we can jump into the frequently asked questions that we got offline. So first couple of updates that I would like to talk about is the recent lawsuit on the H1B fee increase. I've heard there are a couple of lawsuits from two different organizations. Do you have any update on this?
Apparently lawsuits have just been filed, so they are not at the hearing stage yet. But yes, ALA has filed one, and I think a non-profit organization filed the other lawsuit. So basically what they're saying in the lawsuit is a lot of waivers, fee waivers have been removed. So, there was a reason why USCIS or the government provided fee waivers for certain people who can't afford the fees. So those have been removed. So obviously that is not, it's against public policy. And the other thing is like asylum fee, the things, naturalization, they've almost doubled it. So this is again, people are worried that it is a way of disenfranchising, voters by increasing the fee to such an extent that, it's difficult for them to naturalize. And usually traditionally naturalization fee has always been low. So this, because, the reason behind it is being questioned, and basically the fact that there are no fee waivers and that there is such a huge increase in fees over such a short period of time is also being questioned. So let's see what happens. Overall, it's not a good thing. And yes, USCIS keeps saying that, they don't have money, they're bankrupt, but they're a benefits organization. And the opinion seems to be that the fee is not being used properly. There is no checks and balances on, there's no audit process on how the fee is being used and what it's being used for. And that is another concern that they have raised in the court case as well. So let's see what happens.
Yes, sounds good. Another update that last week we had was the EAD printing delays that USCIS has announced, and they have announced the flexibility for the I-9 policy just using the I-797, and it's kind of confusing for viewers as there are dates on it which says they are only from December of 2019 until August 20th. Now a lot of people have questions. So is USCIS considering to speed up the process after August 21st, because they only give certain dates, to use the I-797 as I-9, exception for the I-9. So do you have, some thoughts on it?
So yeah, I mean, we have been advising clients even before this USCIS, the press release came out, that, worst case scenario, if the EAD card doesn't come. So just to backtrack a little bit, what's happening is first of all, there's delays in I-797s, right? In the H4 EAD situation, there has been delays in approvals itself. People have been waiting 6 months, 8 months, and they still have not received approvals. Now, to add to that, even after getting the approvals, the EAD cards are not being produced and sent to them. So there is no proof. That EAD card is supposed to be proof that you can work, and that you're supposed to show that to your employer. And the employer is then supposed to update the I-9 records with that EAD card. So now in the situation where the EAD cards are not being produced because of some mismanagement from USCIS. This is a classic example of why more money shouldn't be given to them without some kind of oversight. They fired the contractors that were producing the EAD cards, and so now they have no one producing the green cards or the EAD cards, which is a ridiculous situation to be in. I've never seen that. So anyway, coming back to the point that because of this delay, we were advising clients to just use the approval itself, the I-797 approval, as proof for I-9 verification. And in the I-9 verification, there's drop downs because it's done online. And the drop downs, you can just use other as the drop down, or if you're filling it out by hand, whatever way you're doing it, you have to fill out the other part. So then soon after this ALA conference, and we started giving this advice, there was a notification from USCIS that this can be done. And they're saying that I-797 approvals can be used. Now, I'm not sure why they're giving shorter durations on the I-797. What I've seen is 1 year durations, but Ranjit, if you're saying that you're getting shorter durations, I haven't seen that.
No, not that exactly. What USCIS says was from December 2019 until August 20th of 2020, whoever have not received the EAD cards can use I-797. So they gave only August 20th as the date. So what I was talking is,
okay, got you. Okay, right.
Who are applying after that, are they supposed to
I
get
think
faster?
something might happen. I understand your question now. So you're wondering why that dates, they've given those dates. Well, there's one thing that we will talk about further, but is the in the House, there was a bill passed recently for right. So one of that, right. So one of the aspects, I mean, of course, it's not finalized because it's not passed in the Senate. But one of the aspects is that, they're trying to increase the revenue from USCIS by increasing the premium processing fee, again, increase in fee. But they're providing various options, and they're providing premium processing for most cases now, including change of status, extension, and one of them is the EAD. So they're providing premium processing for that as well. So maybe they hope that with the premium processing, advent of premium processing, the processing times will increase. And maybe USCIS is also looking into it because there's so many lawsuits, as you know. So they really have to be looking into processing times, and that's one way of forcing them to do so. So I'm hoping that maybe something is happening behind, behind the curtains, but we haven't heard. But that is definitely an indication that they might be increasing the processing times, or rather they might be making it faster.
Going back to the question that we were, you were discussing now about the bill that passed House and it should go to Senate. The premium processing, there are a lot of changes. The fees hike is almost double. It's about $2,500 for a lot of applications. And even the number of days of adjudication has been increased, I believe, to 30 days. So do you think this is, is this acceptable? But USCIS is a funding-based organization where they already get funding and they are supposed to process on time. But then because of delays, they are not doing. But now even premium processing, the bill says it could be increased for certain petitions also that were not done in premium in the past, like H4 and all, by taking a lot of money and increasing the number of days. Do you think this is really worth it, or?
Yeah, first, just to go into the summary of what the House has passed, because that's important. Because if the Senate passes it as well, it becomes law. On the whole, premium processing obviously allows wealthier people or employers to get their cases processed faster, and poorer people and like asylum and these kind of cases, they're obviously the ones that cannot afford premium processing, or the ones that don't have premium processing. Those cases will get affected, which is unfair because obviously if they are moving their resources to one thing, I'm not sure how the other cases will get affected. They might get affected because they're already, as they say, cash strapped. So that is my concern. And as we know, it's when they're taking money as it is, the USCIS fee is quite high, and they're increasing it now. As it is, I think they should provide services within 45 days. And here they're saying that they will take extra money to provide services within 45 days. So what the bill is saying is that the ones that already have premium processing, they're straight away increasing that from 1440 to 2500. And the only exception they've given is the religious visa and the H2B, the H2B seasonal worker visa and the religious visa, which they're saying will be 1500 instead of 1440. And they're also saying that premium processing services should be made available to following other additional immigration benefits with fees and timeframes set forth. So they're saying with reference to EB1, EB2, EB3 that don't presently have premium processing. For example, if you don't have the original labor cert, there's no premium processing for EB2 and EB3. Some employment-based non-immigrant petitions not already subject to premium processing. So these cases, they're saying that USCIS should look into it, make a rule, decide how much time, processing time they can handle, and put in premium processing. And this is also for change or extension of any non-immigrant status, which could be B, could be F, could be change of status from visitor's visa to student visa, applications for employment authorization, any other immigrant benefits that USCIS deems is appropriate. For all these cases, the House is saying that they are not saying how much fee should be or how much the processing time. They're asking USCIS to decide that and publish regulations. And they're saying USCIS has to make adjustments twice a year to account for inflation, which means that the fees could further go up. Now, I understand that this is extremely useful, especially in the EAD situation, but it's just sad that USCIS is forcing people to pay for what should otherwise have been a benefit included within the high fee as it is. And given the fact that some of these applications have to be filed every year, like advanced parole, EAD, B2 extensions maybe because they give it only for 6 months, such things. I mean, it's just sad that they're forcing people to now pay such a huge amount. 2,500 is not, a low amount. Also, they're saying that they're going to expand new benefit requests for premium processing. So EB1 multinational executives, they're saying that they're permitting USCIS to set premium processing fees for new benefits without making any additional rules. So this can be implemented immediately. So basically EB1, so L1, people who are on L1 filing for a green card, and EB2s involving national interest waiver. If it is less than 2,500 and the processing time is less than 45 days, they can immediately start issuing doing these premium processing requests without any rulemaking. Same thing for F1s. If the fee is less than 1750, so they're saying premium processing fee, they're going to put it as less than 1750 and give a processing time of 30 days for F1s. Then they can start immediately without any publication of any rule. Same thing they're saying for E's, H's, L's. If the fees are less than 1750 and processing time is less than 30 days, then they can immediately start. There's no rule making necessary for these kind of cases. So the House is giving authority directly to start. So these are the some of the things that have come up in this House regulation, and I think it's important because in the bill, because it might be the future, because this is the way for them to kind of increase increase the revenues that they have and also provide benefits. The biggest draw is, I think, H4 EADs and H4 cases. I think for them it will be most beneficial. But I think the court cases will not stop, because this is not what they're fighting about. They're saying that within the fees that they've been asked to pay, the processing times have to improve. So, let's wait and see.
Yeah, it's kind of good thing for people who want to expedite the process. Another way around is it's expanding premium process to almost all of the petitions. That way, people who want to expedite, they can. And the
But
other
it's
thing
really
is,
worrisome, Ranjit, as to how it's going to affect non-premium
True.
cases. So that means
True.
nobody will be able to file in premium, because how many months will it take them? They hardly have any staff as it is. We know that they are not able to process cases. So how are they going to now process all cases premium, or majority
they
of
may
them
dedicate
premium
majority into premium, and that may
into the premium
become
processing? Yes, right.
regular backlog
Because
may increase.
the House does not talk about USCIS increasing their staff or any mandate for them to increase their staff. So that's a little scary. I don't know.
And this is, in other words, to cope up with the deficit that they have already, increasing the fees and allowing new premium process for expansion of the other benefits. So this way they can come up with the deficit they already have, and maybe stop the furloughs. But then, yeah, as you said, we have to wait and see, because regular process backlog may increase significantly, and which is not fair for a lot of people who cannot afford. Especially premium is kind of a privilege, and not all employers pay for premium. And a lot of employees, even people who are part-time, or let's say who doesn't have so much money making in terms of their family and all, will be affected. So let's see how this is going to. Other thing that USCIS recently published, which is already in place, but they are reminding everyone, especially the F1 students, post completion of OPT and DSOs as well, of the severe consequences for not employing the employer information into SEVIs. And they are saying that if you're not entering, or if you're not updating the information, every day is counted against employment. So do you have any thoughts on this, and how many employment days are allowed, and how this is going to be implemented?
Right. So I mean, this is so they came up with a new notification that if the DSO doesn't update the CVIS record with the employment for OPT students, post-completion OPT, they'll have to face severe consequences. And they'll be considered to be, unemployed at that time. But this has always been a rule. Maybe because of COVID, a lot of DSOs maybe have not been doing it, or USCIS is worried that it will not be done as it needs to be. And they're just warning people that, just because it's COVID, we're not going to give you any relaxation on this, and you have to follow the law. I think it's more of that. They're just warning people that, no matter what, they have to follow the law. But otherwise, it's always been the law. And they're reminding that if you don't update it, we will treat it as, counting towards your unemployment period. So, I think it's nothing new. I think they're just reminding people as to follow the law.
So I believe the unemployment maximum period in the OPT is about 90 days, right?
Yeah. So, and there is also an additional period for STEM OPT. So they usually calculate all the days together when they say, how many days you can be unemployed. But for the post-completion OPT, remember, the employment can be voluntary, and it's 20 hours a week. So it's not really paid employment, unlike the STEM OPT, which is the second OPT that you get if you are an engineering or math student or science student. The post-completion OPT of 1 year is given to all students, no matter which course they're in, science or non-science background. And for them, it's basically even volunteering is enough. So they don't have to, they can intern. They don't have to be actually paid. So, but they have to have some kind of an internship at least. Otherwise, it will be considered to be, they would have been considered not to meet their requirements.
So USCS may strictly implement these and count, and maybe they want to get students in trouble if they are not doing it. Okay, so we have some FAQs. Let's go one by one. So after the H1B 6-year max out, what are the options the employees have if they want to stay in the country while waiting for their PERM approval or I-140 approval? Can they switch it to F1 or any other status? Can you throw some light on it?
Yeah, so for a person who has 6 years, as we all know, just to backtrack, a H1 person can be on a H1 only for 6 years total. After the 6 years gets over, they can leave the country, stay outside for a year, and then they get an additional 6-year period. So that's one way of doing it. The second way is if they have any vacation time that they took, meaning that if they stayed outside the country during the 6 years, maybe they went on summer vacation for 1 month in a year. So maybe they can recapture another 6 months out of the 6 years, 1 month every year, if they were out of the country, that is. So you can recapture that period. So that's one way of getting a further extension of 6 months or more on your H1. You can just file a regular extension after the 6 years is over to recapture your unused period. And the third way is if you have a labor cert or the labor cert is approved and the I-140 is pending for more than 365 days since the start of the labor cert process, then you can get a 1-year extension on your H1. And then the last part is if you have an I-140 is actually approved and not pending but actually approved, then you can get 3 years extension on your H1, and you can pretty much keep on extending it for a period of 3 years until you get your extension. So it becomes perpetual almost. So that is possible. And of course, as you were saying, if you haven't filed your green card or you haven't filed it on time and none of these other options you want to use or you maybe are not able to use them, then you can file for a change of status, from a H1 to an F1 or a visitor's visa, but this is only temporary. And it will not allow you to go back onto H1 unless one of these other requirements is met in the meantime. So it's possible that you might have filed a labor, but you are not able to get the I-140 approved as yet, but your 6 years has already maxed out. Then you can file for a change of status, maybe to an F1 or a visitor's visa. And then once the I-140 gets approved, since you're cap exempt, you can go back, file a transfer again to a H1. So that is a very convenient way of taking care of your status, even though maybe you haven't done things on time, but you can still salvage your status. Or you can leave the country instead of filing for a change of status to an F or a H, F or B2 or whatever. Leave the country for that period of time until the I-140 gets approved or other conditions are met, and then come back on a fresh H1 once those conditions are met. So that's another option as well.
Got it. Before getting into other question, I would like to tell the viewers that if you have to reach the attorney for private consultation, please reach Prashanthi at 212-354-1010 or prashanthi@reddyesq.com. You can reach her in the private, and if you have any requirements, she'll be glad to help you. I would also like to repeat the disclaimer again. Please note that the show is not to provide any legal advice. It is very general in nature, and it is only for informational purposes. Sakshi TV News, our agents are not responsible in any way for your actions. Use the information at your own risk. So another question that we are getting a lot here is about this EAD thing. I would like to ask you this. So we know that if you don't have EAD in hand, you cannot work. But obviously, because of the delays, there is always a little gap. So let's say 15 days or a month, between two EADs, because at the max you can only apply 180 days before an expiry of the EAD. So a lot of people are asking this. Let's say if it's taking some time, what are the options they have? Can they take a break? Or few people were asking, like, can they get paid uh, for the period they work? Let's say, like, they had accumulated some leaves, let's assume, for the period they worked. Can they use those leaves and get paid when they don't have an EAD and waiting for the EAD? Or they cannot work, they have to just take break?
So if you're waiting and there is a gap, then they have to take you off the payroll. The company they have no choice but to take you off the payroll because you're no longer authorized to work. So you would be laid off, I guess, or furloughed, and then rehired. Again, they have to start the whole hiring process and be rehired again because you cannot be on the payroll. Or it's possible that you could be. I mean, that is the correct way of doing it, really. That, laid off and then again rehired once you get your EAD card in hand. With reference to getting your vacation leave or getting a severance, check or something like that, that can be done even after you are laid off, because that benefit is something that you accrued while you had, employment authorization. So they're just giving it to you later. So that is fine. You can take checks.
So paid leave is kind of fine because that's something you have got it for the period you worked. It's not actually work.
Correct. So that is fine. You can take your accrued leave, whatever benefits that you got, you can get a check for that even after your H4 EAD has expired.
True. That sounds interesting. So another question we got offline from one of the viewers is, two scenarios here. It's from two people. One scenario is where the original H1B that's picked in the lottery has been revoked by USCIS because of misrepresentation by employer. He has been here from like 7 or 8 years, and his current extension, he's left that employer, and current extension is still valid for a year or so. Now he was worried that, what happens because the initial H1 that's picked in the lottery, the cap H1B, has been revoked by USCIS, and they sent a notice saying that because of misrepresentation, that H1 is no longer valid. Now this guy, is he legally allowed to work until the expiry of the H1B, or he have to leave because it's kind of the initial H1B is revoked and it's like his H1B is never picked or something like that?
So yes, I have encountered situations in which a year later or 2 years later, they're actually revoking the initial petition that they approved, cap petition.
This has been up to 7 years.
Yes. That's just ridiculous. There should be some kind of a, I think, statute of limitations where they shouldn't be able to go back, to old cases. And, obviously there is some adjudication issue there. So they should have adjudicated it better, or if there's new information that came out, there should be a way of, adjudicating this whole situation better. And most times anyway, what the employer does, the employee doesn't know. So then to penalize the employee for this doesn't seem to be fair in this situation, because employer, maybe the company is even there, or maybe they're not even there in business anymore, but the employee is still there. So, and they are the only ones that get affected by this. So anyway, in that situation, if the present H1, there is no NOIR or no notice of intent to revoke on the present H1, even though the previous H1 was denied or revoked, you have to wait until they actually send a revocation on the present H1. Until then, the H1 is valid because it has not been revoked. That is the onus is on USCIS to actually send a revocation for the present H1 as well.
Oh, got it. But the other question that bugs everyone is, like, initial H1B that's picked in the lottery is revoked. So it means kind of you don't have an H1. So it's still okay until USCIS revokes the current petition.
Correct. Yes, it is, because they have to. It doesn't automatically get revoked. They have to actually revoke it. If they approve a H1, there's no automatic revocation. They have to send a letter, which is easy enough for them to do, but they'll provide some kind of a period. There might be an appeal period, whatever it is. So they have to go through the process.
Okay, got it. Now, another question a lot of H1B holders have is, can H1B holders start a business in the US? Can they have a business on their name, or can they start with a green card holder or citizen, and take the profits as well as then transfer an H1B to that company? There are three parts of the question.
Yeah, so I mean, yes, a lot of H1s are very entrepreneurial, and unfortunately, they have to be on H1 for years and years together. So, people who want to start small businesses, unfortunately, because of the way the green card numbers and everything, they're not able to. And this is one of the things that policymakers should know, that they are stifling growth and the economy and the ability for them, these businesses to provide employment. You'd be surprised, 1 out of 5 people on a H1 want to start their own company, especially in the IT business. So, and that is really being is being diminished because they're unable to do it. So, with reference to whether they can do it or not, I mean, this is what I will say to them. I mean, you can own shares in a company, you can invest in a company, like any company, whether it be Microsoft or it be ABC, the size of the company doesn't matter. But you're allowed to invest on a H1B, but you're not allowed to actually work. So you can invest in that company as a shareholder or part owner, but you cannot take care of the day-to-day activities of that company as an investor. You can only be a passive investor. So that is possible. You can invest. But if you want to be an active part of the company and start working, then you have to get a H1. And it could be that you don't want to leave your job, so you could get a part-time H1, concurrent H1 for that company. But remember, if you are a part owner of the company and you try to get a H1 through that same company, you might face issues, because it's difficult then to establish the employer-employee relationship. In the past, theoretically, as per the regulation, it is possible, as long as you're able to establish that there is, even though you have a share, there is an employer-employee relationship, as long as you're able to establish that. But recently, of course, USCIS has been less and less willing to approve such cases. But in the past, those cases would get approved. So let's see what they do now, since this whole employer-employee relationship concept has been debunked. Maybe they'll be a little bit more liberal with reference to these kind of cases. So I think as long as you don't have control over the country, so you don't have a controlling number of shares, that means more than 50%, it is possible. There's no harm in trying, because your present H1 doesn't get affected, because you're filing it as a concurrent H1 and as an additional H1.
Okay, got it. Another question from a viewer. So employer they always have a certain wage on the LCA they pay, but usually every year they get increments. So every year they get increment. Do they have to amend, or doesn't matter as long as employer is paying whatever is required or more than that? So if they are getting paid more, is it okay, or still there is a need of amendment every time there is a raise or increase in the salary?
Only material changes in the petition require amendments. Not every time some small thing happens, you need to amend. Most importantly, if you're changing your work site to a different MSA or different county, an amendment is required. Otherwise, just change, maybe some of your job duties are changing, or you've received an increment, as you said, in your salary. In that situation, as long as you're getting paid above the prevailing wage, whether the salary is increased or salary is decreased, you don't need to file an amendment in that situation.
So let's say because of this COVID, a lot of people are working from home. So when they are working from home, especially the employee, what does the LCA require in regards to the notice? Do they have any requirements in concern, especially if within MSA and if it's outside of MSA, both the scenarios?
So if it's outside of the MSA, then they have to file an amended petition. If they're working from home now and the home is not within the MSA as per the work location in the LCA, but if they are within the same county or MSA as we call it, and they have moved from their office to their home, they're working from home, then the posting requirements are still there. but you just simply have to post it on your refrigerator or in your house, that is the posting requirement. You have to post the LCA on your refrigerator or in, the main area, living area. So if anyone does come for an inspection, they should see your posting. That's all the requirement is. And you can also post online if your company has like an intranet service. I think you should do both. You should do online as well as, post it in your house.
Got it. So let's say an H1B transfer is filed. When can the employee start working legally? Do they have to wait until they get the receipt, or they can work as soon as the petition reaches USCIS? Are there any regulations regarding that?
Yeah, basically AC-21 regulations says very clearly that once in a transfer situation, once the H1 is received by the USCIS, they can start working. So they have not said anything about that it has to be fee receipted. They simply say that it has to be physically received by USCIS, and that can be determined if you send it by FedEx or some courier services. If you send it by regular mail, you may not be able to get a confirmation of the delivery, but express mail or priority mail, courier services, you'll be able to get a confirmation of the delivery and they can start working on that day.
Got it. Another question is, let's say an employee transferred to another employer, but then he's not happy with them. Can they go back to the previous employer if it is not revoked, and what happens if previous employer already revoked the petition? So two scenarios here.
So first of all, yeah, that is a kind of a gray area, but if you file a transfer and if the transfer is not approved, remember, not approved, the transfer should not be approved. If the transfer is approved, then being able to go back to the previous employer without filing a petition is something that you cannot do, at least as per me and most what attorneys will say, but some again might say it's a gray area and that you can go back and forth, as you please, as long as the petition has not been revoked. But in another scenario, if the transfer has not yet been approved and you your employer withdraws the transfer, then yes, I think you can go back to your previous employer, of course, provided that H1 is active in the sense that it has not been revoked. As long as it has not been revoked, yes, you can go back. If it has been revoked, then you're out of luck. And then pretty much you're out of status because you're neither here nor there. So you'll have to leave the country. Or maybe you can ask for time from your employer, second employer, not to withdraw the case, and while the case is still pending, file for another transfer, file for a change of status to another, another status like an F student status or a B2 status. So that's possible to salvage your case in that way.
Okay, another question we have is, what are the steps an employer have to take, especially in this COVID situation, if let's say the employer wants to convert the employee on H1B from full-time to a part-time basis because they don't have enough work. So what do they have to follow, and exactly what needs to be done?
Yeah, so if there's not enough work, people don't seem to realize that they can file an amendment to a part-time H1. And they often just lay off their employees. That's not a good thing. I mean, you have to remember that there are other ways of doing this, and one of them is, as I said, filing an amended petition for part-time. And that way you don't have to lay off your employees, and you can also use the PPT fund that you're receiving, right, from the government. So, and keep your employees on the payroll and get, less revenue. At least you'll get some revenue rather than getting no revenue if you lay them off and completely stop the project. So file an amended petition, and remember, you only have to file it, and then they can start working on in the part-time position. The case does not have to actually be approved. It only has to be filed. And in the meantime, given our processing times, the delay in processing, by the time it gets approved or before that, maybe he will move back to a full-time position, in which case then you just withdraw it. And your previous, whatever the previous H1 is, you can continue using that approval. So, that this is a good technique for people, employers during COVID especially, to file part-time petitions rather than laying off their employees.
I would like to tell the viewers this thing that, if you have to reach the attorney for a private consultation, please reach Prashanthi at 212-354-1010 or, Prashanthi at reddyesq.com, and she'll be glad to help. So another question, a lot of people have here is, what happens, when H1B is not getting paid, even when he's in a H1B, like a bench period? So is it really allowed, or the employer have to start looking for a job, or is there any certain period that someone can be benched?
So it really depends on why the person is not working. So the unemployment period, the non-productive period, as it's called, is a period in which the employee is not actually working for the employer. But the non-productive period can be caused either due to the employer saying that they have no work, or the employee saying that they cannot work due to some circumstances. So if it is the employer saying that they do not have any work for the employee, then, and if they bench them or they furlough them, then they have to pay. They have to pay the employee in that situation, unless they are laying them off. Then they have to, if they have to either lay them off and withdraw their H1, or they have to pay them. There's no other way around this. But if the employee is not reporting to work due to health reasons, for example, maybe maternity reasons, because they're sick, or they're taking care of a loved one, taking care of a family member, or they're just gone on personal leave. And in that situation, then the employee does not have to pay them. Very important to understand the distinction between, the employer not having work and the employee not reporting to work, the two different situations. So in that situation where the employee is not reporting, they don't have to pay, so they do not lose their H1B status. And as long as the leave is established and, there's something in writing saying that leave was granted, they can remain on leave and not be paid and still maintain their H1, as long as there is no law which requires the employer to pay in that situation as well. For example, maternity leave, in many states, the employer is required to pay family benefits leave. So there's some acts in different states where you're supposed to pay in certain situations. Otherwise, if there isn't, then you don't have to pay. But an interesting twist to this, Ranjit, is if in COVID situation, for example, the employer doesn't want the employee to come to work because they have to be quarantined. So here in this situation, the employee is not refusing to come to work. The employer is stopping the employee from coming to work. So it could be argued that the employer has to pay in such a situation because the quarantine is being imposed by the employer. So this is a very interesting situation where, public policy requires you to be quarantined, and it's a good thing to do, but the employer is being asked to pay for that period. So, let's not presume that everything, we have to look into every case carefully to see whether the employer is obliged to pay or not. So it depends really on the situation.
Got it. So you were saying that when there is like the pregnancy, maternity leave, so is that allowed not to work? Because sometimes even after whatever the employer pays, there would be certain period, if there are complications, they have to be away from work for a certain period of time. So because, and this is a medical reason, so is that completely fine not to go to work or get paid?
Yeah, if you have some complications due to pregnancy and you cannot, some people, if you have to take bed rest, or even after pregnancy, if your child is sick, even the father, whether it be the father or the mother, they can take medical leave. And they, as long as the state doesn't require the employer to pay under some, benefits regulation. The employer doesn't have to pay in that situation. They can get unpaid leave and still maintain their H status.
Okay. When we are talking about this unpaid leave, so is there a need that we have to document it, because these days there are a lot of site visits. So what should be done to make sure that the leave is approved, or it is allowed, or USCIS being notified about it, or what all should be done?
So anything, as long as it's in writing, because who knows what one person has said to another, right? It's not documented. So even an email is sufficient. Anything in writing saying that your leave has been approved, there's a request of leave, and then there is an approval of the leave. That's all that's required until so and so period. That's all. As long as something is documented in writing, even an email is fine.
Okay, got it. Another question a lot of people have is, can there be two different petitions in process at a time? Let me give you an example. So a lot of people whose H1B has picked in the lottery, that's in pending status. Meanwhile, if let's say their H4 or F1 or something is expiring, they file an extension. So what happens when, let's say, H4 and H1B both are pending, and H4 already expired in the current situation, or H4 if H4 is not expired? So two scenarios. What happens, because they have to maintain status until they get H1B? At the same time, two different petitions are pending. So what should be taken care in this kind of scenario?
Right, and nowadays during COVID time, a lot of people are filing two petitions or want to, because they want to ensure that their status, that they remain in status. For example, I had a client. It's very messy, but sometimes it's inevitable and even necessary so that they can maintain their status. I had a client recently who is filing for a H1 with a 60 days grace period, but they're not sure whether the H1 will get approved or not. So they're also filing. They want to file for a change of status to an F1. So they want to file two petitions at the same time, and it's very tricky. But in general, the rule is that there's something called the last action rule, which says that whatever action you took last, that is the final status that you will have, unless you withdraw the petition, before the approval of before its approval. So, for example, in my client's case, if he files both petitions, but if he files the H1 first and then he files the F1, then the last action rule will be that the F1 will take precedence. So if he does not withdraw either of them and both get approved, then he will be, once the F1 gets approved, he'll be converted to F1 status. He likes it or not, even though his H1 got approved and he started working on H1. So in this situation, I would ask people to be very careful and to withdraw the petition that is not needed. Whichever petition is not needed, please withdraw it before it gets approved, so it doesn't negatively affect your status, and you don't find yourself in a status that you don't want to be in.
Got it. So what happens in this scenario? Let's say they want to withdraw actually the H4 petition because H1B is approved, but then H4 already expired and they have to wait until H4 already expired and they need, let's say, status from August until October because H1 only kicks in from October. What should be done in this case? Because they cannot withdraw, at the same time they cannot keep it active because let's say H4 is approved after the H1 is approved, then again H4 will take over. So this is kind of tricky situation where they have to have it.
So right, Ranjit, in this situation, it's a little different because even though you might file the H1, for example, you file the H1 in March, and you file the H1 in June, right? But the start date of the H1 is October 1st. So as per the last action rule, it works a little different here. The last case that was filed will be considered to be the H1, not the H4, because they will look at the start date in this particular situation. So the start date being October 1st, that will be considered to be the later petition, not the H4. So if the H1 and H4 both are approved, they will still be considered to be in H1 status. I know it's a twist and a little complicated, but in this particular scenario, since the start date is in the future for cap cases, the actual date of employment takes precedence, and the last action rule goes with the date of employment.
So another question we have is this progressive experience. So there are a lot of questions on this. So let's say an employee who has a bachelor's degree as well as he has, let's say, more than 5 years of experience will be eligible for EB2. But then there is something called, if you're working for the same company and same experience, which is progressive experience, so can they still be eligible for EB2? What needs to be done? How does it work?
So unlike a H1B scenario in which you can use experience from your present petitioning employer in order to evaluate your degree and say you have the equivalent of a bachelor's or master's or whatever in that field, in the green card situation, you have to show that when the person hired you, you already had that qualification, right? So because they're asking for a certain qualification, they're saying for this job, we need a person who has a bachelor's plus 5 years of experience, 5+ years of experience. So you should have had that qualification before they hired you. So you cannot show that you gained that qualification after they hired you. So basically, you cannot show experience from the petitioning employer in this situation. So you should show that you had it previously. If you're going to show the experience from the petitioning employer, you have to show that it is very different from what is being asked right now. For example, and which is difficult to do, but I'll give you an example. For example, if you're filing for a H1, if you're filing for a green card, EB2, bachelor's plus 5, and you're asking, and it's an IT job. If the person previously worked for the employer in a completely different job, for example, as a, say, non-IT position, as a manager or something like that, and then changed jobs for the same employer and started working as an IT professional. Say previously he worked as a financial analyst and now is working as an IT professional. Then you can use the job, the financial analyst portion of the job as well, to show the experience of bachelor's plus 5. But then you come up with a different situation. They will say that the previous experience was not relevant. You need bachelor's plus 5 years of related experience. It's not any experience, right? Usually the experience has to be related to count towards what you're doing. So if you don't say related experience, you'll get into different kinds of trouble. Then they'll say you didn't say it's related, so it's very vague. The job duties are very vague, and it's not. You didn't test the job market properly. So there are different issues with that. So only in that situation you can use experience gained by the petitioning employer. If it's completely different, at least 50% different. If you're able to show that it's 50% different, so to give a closer scenario, maybe you worked as a program analyst and now you're working as a software engineer, or you worked as a computer programmer and now you're working as a software engineer. It is related, but it is also more than 50% different. So in that situation, you could use, you have to tabulate it and show, how much of it is same and how much of it is different. You could then use experience gained from the petitioning employer. And this is very relevant because in many instances, employers hire these people right out of school. So they really don't have any experience other than experience with their petitioning employer. So that means the person who first hired them cannot file their green card unless they don't ask for any experience. So they'll have to transfer to another company, and that company will have to file their green card. So this is an interesting scenario that plays out often in the labor cert process.
Another question here, let's say employee is in same kind of job, but then he had like a promotion. Let's say he was a software developer, then he became a senior software developer, then like a lead developer, something like that. So will that also be kind of a progressive, because they have been kind of changes in what what he has been doing from the time he joined, and now he has become a senior, like with certain years of
Yeah, that
experience.
itself will not count. So you cannot use that kind of experience gained from the petitioning employer to get your bachelor's plus 5 years of experience, progressive experience, because it's not different. It's not more than 50% difference, and it's difficult to show that just progressive experience is different. There might be more supervision required, but it's pretty much the same job. So in that scenario, you will not be able to use experience gained from your employer.
Okay, got it. So what happens when an H1B employee leaves the company? Do employer have to terminate the employee, or they don't have to do it? Or if they don't do it, and let's say there is an audit from USCIS, what happens? Or is it mandatory that they have to send a withdrawal letter to the USCIS to revoke the petition as they send the termination letter to the employee? Can you shed some light on it?
So yeah, if you're not paying the employee, as we were discussing earlier, you have to terminate their services, and you have to do a couple of things actually. You have to terminate their services by sending them a termination letter. You have to terminate their H1 by sending a withdrawal letter to USCIS, and you have to then pay them for their, or offer to pay them for their return fee, for their return trip back to their own country. So these are the things that you are required as per the H1B regulation when you're terminating an employee.
So the return ticket which we are telling, is it mandatory even, let's say, the employee found another job or something like that? Or
yeah, in that situation they're not leaving, so you don't need to provide it. It's only in the situation where they are leaving the country.
Or like you terminating them and then you're asking them to leave.
Right, because right, you're offering them the ticket to leave. If they don't take it, or if they're not leaving, then you have fulfilled your obligation.
Got it. Okay, the another question a lot of people have is, I think we discussed last time as well, but again to reiterate because a lot of people asked it, the severance pay consideration for the 60-day grace period. So it doesn't matter even if you are getting severance pay for 3 months or 4 months or whatever, the day you got terminated will be the last day, right?
Yes, absolutely. So they will calculate the day that you were actually terminated, that you stopped working, and then they will use the 60 days is calculated from that date. Often people use the severance pay check, especially when it doesn't say that it's severance pay, as proof that they continue to work, and USCIS will sometimes accept that. But yeah, as per the regulation, the 60 days grace period starts from the date that you were actually laid off.
Is there any scenario, or did you come across any scenario where USCIS asked for the termination letter or any other proof saying that you are on grace period? Because these days USCIS are kind of very weird.
Yeah, usually you have to submit some kind of proof to show when the 60 days is getting over. And remember, the 60 days grace period is not something that they have to give you as a rule. That is decided on a case-by-case basis, whether USCIS officer can decide whether to give you the 60 days grace or not. So it's not, we forget that it's not something that is a sure thing, but it's something that is within the discretion of the officer. So they will look at all the circumstances, and of course they will look at the date when you are terminated. So they will either ask for your last pay stub, or they will ask for a termination letter to show the actual date of termination.
Got it. So another question here is, let's say it's a startup company, can they still file an H1B because they don't have any revenues, they don't have any anything established? Is there any rule that it has to be established for a certain period of time and have some revenue to file an H1B, or how does it work?
Right, a lot of people ask me this question. It's a very common question that we want to start a company, we want to file our first H1. Do we need to show X amount of money in the bank? What do we need to show? So the only thing you need to show is that you have an office space, not a residential space, not out of your home, but an actual commercial office space. The size of the space really doesn't matter. It depends on what your needs are and if it meets your needs. And the other thing, of course, you have to show that you have incorporated a company, you have a bank account. It would be good if you had a website, because they usually go to the internet. They Google your company name, USCIS, to find out, more about your company. So it's good to have a website. It's good to be on the Dun & Bradstreet DNB register there. It's a free registration, is free on the DNB website, so it's good to register there. I would suggest that, because they go to that to verify your company. USCIS does that. And then with reference to revenues, you don't have to show any revenues. The only thing you need to show is that you have a need for the employee that you're seeking to hire on a H1B. And you could show that need either by showing the contracts, by showing the POs, or otherwise showing what your business is about, maybe your POs from your customers, whatever it is. You have to show that you have a need for that particular employee. That's the only requirement.
So as long as they have a real work, anyone can file H1B irrespective.
Correct. Yes.
Got it. So I think we are towards the end of the time. I would like to again say, if you need any private consultation, please reach Prashanthi Garu at 212-354-1010 or prashanthi@reddyesq.com. Thanks, attorney. It was nice talking to you. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday, and please watch the show at 6 p.m. EST, the Immigration Talk Show. Again, it's every Wednesday, 6 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Prashanthi Garu.
Thank you.